I am delighted to open this panel on the social impact of collective actions. I must start and say that yesterday the greediness issue raised by former Chief Justice reminded me of an important antitrust decision of the US Supreme Court, Trinco, where they concluded that the mere possession of monopoly power and the charging of monopoly prices is not only not unlawful, but it is an important element of the free market system. The opportunity to charge monopoly prices is what attracts businessmen in the first. So, is it really the opportunity to charge monopoly or excessive legal fees that attracts the plaintiff lawyers in the first place? I ask myself, is this the case with human rights, vulnerable populations, and public bodies? Our first panelist is Professor Maurice Ratner from UC Hastings College of the Law. Professor Ratner teaches civil procedure, legal ethics, and the business of law. Professor Ratner.
Thank you very much. So I have to preliminarily say I resist strongly the use of the word greed. I think it's so loaded. We're really talking about incentives, and I've spent the last several years thinking through as a scholar how to harness the incentives that fee payment at the end of collective litigation can accomplish. And just because lawyers are motivated by profit does not mean that there's anything wrong with that. We want to encourage investment in the right kinds of cases. That said, I'm here talking today about the social impact of collective redress through the prism of a particular category of litigation, the Holocaust-era class actions that I'll describe in a minute, and a comparator, the more recent Anti-Terrorism Act litigation that was successfully prosecuted in US courts against the PLO and Palestinian Authority. And I am speaking now not so much as an academic or even as a former practitioner, but just on a very personal level about my experiences as one of the principal lawyers in the Holocaust-era class actions, and am really just sort of ruminating out loud about a question that has weighed on me since we really resolved those cases now about 15 years ago, which is whether we did the right thing. And I'm not asking whether we should have settled those cases. I'm not dusting off an old Owen Fiss article called Against Settlement from many years ago that many of you may have read. I'm asking more narrowly, did we accomplish resolution of the Holocaust-era cases at the right collective redress unit? Did we define the boundaries of the dispute for resolution purposes properly? And two recent events have triggered much of my thinking in this regard, my most recent thinking. One is in 2013, I was invited to speak at a synagogue in Cambridge, Massachusetts via Skype for a Yom HaShoah a Remembrance Day event that they hosted, and I was one of two speakers. I was speaking about Holocaust-era litigation and what we accomplished in those cases, and the other speaker was a survivor who had been in a slave labor work-to-death program in Germany during the Holocaust and had survived and was telling his story. And he was the first speaker, I was the second speaker. And the reason I was invited was that most of the survivors are passing on, and they wanted some new way of thinking about how to remember the Holocaust, how to celebrate Yom HaShoah. And the thought was that maybe they would talk about the use of litigation to achieve social justice as a way of thinking about the Holocaust once there were no more survivors who could tell their stories directly and personally. Anyhow, at the end of the survivors' presentation, they transitioned to me, but they first wanted to ask him, well, what did you think of the Holocaust restitution litigation that Mr. Ratner and his colleagues prosecuted and settled? And his response was a very negative one. He said that as a survivor, entitled to a reparations payment under the settlements we negotiated of $7,500 per slave laborer, he was insulted by the outcome. And I had heard about survivor criticism of some of the aspects of what we accomplished. In the aggregate, it was quite dazzling. We accomplished through the German Foundation Agreement I'll describe shortly a $5 billion resolution of slave labor claims. But the way we decided to allocate this money was on a per survivor basis, and it was not appreciated by many of the survivors. The second event that triggered some of my current thinking on whether we had the right level of aggregation in the Holocaust cases is the Anti-Terrorism Act litigation against the PLO and Palestinian Authority that led to a jury verdict earlier this year of several $100 million. It was prosecuted on a very small aggregate basis. That is, about 40 individual claims were consolidated for pretrial and trial purposes, and the average payment in that case per plaintiff was $5.5 million. There are many differences between the two categories of litigation, as I'll note in a moment, but one of the primary distinctions in my mind was the unit of aggregation. One last introductory comment before I launch into my slideshow here. Though the impulse has been tempered in U.S. Class litigation for reasons described by my colleagues, Linda Mullinex and Rhonda Wasserman, the impulse is still, nevertheless, especially in human rights litigation in U.S. courts, to go large, to define the largest unit of potential adjudication and settlement for a number of reasons. The plaintiffs' lawyers in these cases are jockeying for position vis-a-vis other potential lead counsel in these cases. The lawyers want to legitimately present the defendants with the largest potential liability and want to create more media pressure, which is central to the success of some of these cases, and more interest among political figures, which is also central to success in some of these cases. And so the Holocaust-era litigation really was the result of that same impulse. So let me say a few words briefly about the Holocaust-era litigation. I haven't produced scholarship in this area for now about a decade, but I have some scholarship out there, including a 2002 article I published in the UC Berkeley Journal of International Law, along with a number of my colleagues who were involved in the litigation that provides much more detail than I will provide here. You can also Google my name and on YouTube, and you'll find a talk I gave last year on this that's much more involved than what I'll be saying here. But in general, when we talk about Holocaust-era class actions, we're talking about 100 class action lawsuits that were filed between 1996 and the late 1990s, and all settled by the end of the Clinton administration against private entities in 4 countries, Germany, France in particular, and against Switzerland. And then the last one wasn't a country per se, it was just an all-Europe sort of insurance company category of litigation. But the common denominators were that we sued private corporations. We alleged in each of these cases that the defendants aided and abetted Nazi Germany or profited from Nazi-era atrocities after the Holocaust. We asserted a mix in each of these cases of international law, U.S. state common law, and foreign non-U.S. state law claims. And we sought in each of these cases a mix of equitable remedies, for example, an accounting and disgorgement of dormant accounts in the Swiss case, and legal damages. For example, damages associated with personal injury claims for slave laborers. And we settled all of these cases on an aggregate basis. Professor Molinex was just talking about some of the different models. We used two of the models that she described in the Holocaust era cases. We used the traditional class action settlement model in, for example, the Swiss litigation, Swiss bank litigation, and we used a non-class model for the German slave labor cases, the other largest category of litigation that we resolved. I'm going to focus in this talk just on one of the categories of litigation that we pursued, litigation against the Swiss banks, by way of example, the way we prosecuted and settled that, and use that when I compare the Holocaust-era litigation to the ATA Anti-Terrorism Act litigation. So the Swiss bank claims were filed in the mid-1990s, starting in 1996. The trigger for this was the discovery of dormant Holocaust victim accounts that the Swiss banks hadn't previously acknowledged in connection with any of their prior voluntary audits. And the plaintiffs' lawyers, myself included, who prosecuted these cases, alleged a mix of claims. Of course, the dormant account claims were the core of the case, but we also sued the Swiss on behalf of proposed worldwide class of Holocaust victims for the function that they performed in laundering looted assets, including Nazi gold, and for transacting in the profits of slave labor, knowingly transacting in the profits of slave labor. These cases were all consolidated before one single judge under Rule 42 in the U.S. system, Judge Edward Corman in the Eastern District of New York. And within a couple of years, we had an agreement in principle in 1998 to settle these on a class basis, and we received final approval of those settlements in 2000 to resolve the cases for an aggregate payment by the Swiss banks of $1.25 billion. And that claims process that arose out of that settlement just wound down actually last year. It took close to 15 years to distribute the dormant account claims because it was an adjudicative claims process that was involved in that portion of the case, which was the largest portion of the settlement. So I think this slide is interesting. It shows you what happens typically in mass torts in general, but certainly happened in this case in a dramatic way. We carved out in our allegations already a quite large unit of adjudication, a worldwide class against the three major Swiss banks over which we thought the United States courts would have jurisdiction, claims involving deposited assets and their profits from slave labor and looted assets. And we reached an impasse in 1998. We and the partner organizations who were advising us in this litigation, Holocaust victim advocacy groups, wanted $1.5 billion, and the Swiss banks indicated they wouldn't pay a penny more than $600 million. So we had this gap between us. And as is common in mass torts, the gap was bridged by expanding the scope of the litigation for settlement purposes. So we went from a case against some Swiss banks, primarily involving dormant accounts, but also involving other claims, to an all-Switzerland settlement. The settlement was one in which the class members would release their claims against any Swiss entity having anything to do with Holocaust-era conduct. That became the $1.25 billion Swiss bank settlement. And that included, for example, claims we would never have been able to prosecute in US courts, for example, against the Swiss government involving refugees who were turned away by the Swiss government when it was known by the Swiss government that they would be sent to concentration camps. We couldn't sue the Swiss government for various reasons, but we could settle those claims in a class action in US courts. So here's how the money was distributed, the $1.25 billion. Most of it went to pay the most valuable claims, those that had the greatest likelihood of success in court. So $720 million was paid to deposited asset claims. This is all available on a public website, www.swissbankclaims.com, with an average payment to those persons who had dormant account claims, usually heirs of Holocaust victims, of about $185,000, and a much smaller payment, average payment, for plausible claims where the evidence had been destroyed by the Swiss banks, but we thought plausibly there existed evidence of an account. The looted asset claims were not really triable claims. The reason being that we couldn't link any particular plaintiff to any profit that the banks may have earned on looted assets. We just knew in general that the banks were instrumental in laundering stolen gold. So that was allocated on a cypre basis, $250 million, most of which went to survivors, Jewish survivors in the former Soviet Union who had not received any other sort of reparations payment from Germany. The refugee claims, similarly, were not triable claims. We could never have prosecuted them in a U.S. court. Those were settled with pro rata per capita payments, $3,625 for persons who were expelled from Switzerland and sent to camps, $725 per person payments for survivors who had been detained. And the slave labor claims got $281 million in the allocation of the Swiss bank settlement, which worked out to a per survivor payment of $1,450 per survivor who had been in a slave labor program. The Swiss bank settlement was coordinated with the German settlement, the German Foundation Agreement that we negotiated, so that $1,450 per person payment was added on top of the per person payment available under the German program, which was $7,500. So the Swiss banks litigation produced the largest human rights settlement in U.S. litigation history, right? On an aggregate basis, it was a fairly dazzling settlement, and even though some of the claimants received relatively small sums, it was a significant victory by most accounts. But it has produced over the years 3 dominant narratives, which I outlined on this screen. One narrative to which I helped contribute is that the outcomes in all of the Holocaust cases, including the Swiss banks litigation, demonstrate the power of collective action and of the class action in particular to produce outcomes in U.S. courts that wouldn't really be achievable anywhere else. Other contributors to this narrative include Michael Basler, a U.S. professor who's written extensively on the Holocaust cases, and Bert Newborn, who was one of the lead lawyers in the case, with whom I worked closely over the years. Second narrative is that the litigation was an affront to the individual experiences of Holocaust victims by translating them into dollar figures, and in giving closure, legal peace to the defendants, gave them something they didn't deserve. Abe Foxman of the Anti-Defamation League was one of the key proponents of this view. It was, in my opinion, just based on my review of the sort of press coverage and dialogue around this Holocaust cases, a minority view, but he was quite prominent in expressing it. And the last dominant narrative is that the Holocaust cases were sui generis. They're not really helpful in this view, in that the cases were largely politically driven, and Michael Allen wrote an article that, while he was still a law student, I believe, at Yale, but it's been widely cited in 2009, taking this position, calling the Holocaust cases a cul-de-sac of development of international law, that nothing would basically come from it. Each of these dominant narratives has some merit, actually, but I think each one is incomplete. The Swiss litigation was, for example, the largest human rights settlement, but its payments to some categories of claimants, like slave laborers, bore no relationship to their actual injuries. And while some commentators criticize the effort to monetize Holocaust-era claimants' experiences, those claimants who did well in these settlements were quite grateful to get compensation, for example, for accounts that had been previously undisclosed by the Swiss banks. And while some facets of the Swiss banks case and other Holocaust-era cases were sui generis, including especially the degree to which they were politicized, in many ways they followed a very familiar mass tort litigation trajectory, and so from that vantage point, I think it's still useful to think through whether we did the right thing in those cases, because there will be other human rights cases and other mass torts, and we'll be confronted with the same question, which is what's the right unit of adjudication in these cases. So I'll be asking two questions as I go forward in the rest of this talk. How can we best judge the efficacy of the collective action in the Swiss banks litigation? And does the recent Anti-Terrorism Act litigation in the US point to a better way to pursue collective redress? I think there are 5 measures I've pulled out for assessing the efficacy of the Holocaust-era cases in general and the Swiss cases in particular, and I'll quickly review each of them. In terms of the compensation that they produced, one way of assessing the efficacy of the compensation is to ask, well, what happened before we pursued these Holocaust-era cases? And the answer is not much. Most of the persons who were claimants in our cases did not pursue individual claims. There was very little activity, certainly very little aggregate litigation activity before we prosecuted these cases, and so there was very little compensation. However, in 1996, there was a settlement of a slave labor case, the Prince case against I.G. Farben, that produced average payments per plaintiff of $190,000, which our average per person payments pale in comparison to. My theory is the reason is largely because it was a smaller case. So once the cases get to be of a certain size, there are just so many claimants, the aggregate numbers get so big that to reach a settlement, we have to tolerate lower per person payments. And actually, I didn't put this on any of my slides, but more recently in 2014, Holocaust-era litigation that I was not involved in, that I don't lump into the ones I've been talking about, settled against the French Railway, SCNF, for its role in transporting victims to camps. And 600 American survivors sued the French Railway. That was settled on a similar basis to the ones we settled 15 years ago, but the average payment is $100,000 per person. Again, oh my goodness, I'm running way out of time. All right, so on a deterrence level, I think we did not, other speakers have talked about deterrence as being hard to gauge in these aggregate cases. And that's absolutely true in the Holocaust cases. In terms of norms, I do think the evidence there is mixed as well. That we did sort of establish some norms in the Holocaust-era cases, and there's a great article to which I'll refer you to since I don't have time to talk about it. Bilski, Citron, and Davidson from 2014 in the Stanford Journal of Complex Litigation that talks about the litigation from that, through that lens. It could be argued that one of the ways of assessing the efficacy of the Holocaust-era litigation was to see it as through the prism or lens of the process values that we accomplished in those cases, allowing claimants to participate in a legal process in order to have their voices heard. I think the evidence there is mixed as well. And the victim response was clearly mixed, as the story with which I opened demonstrates. So I won't have time to go into too much detail on the comparator, unfortunately, in this talk, but I do think that what distinguishes the ATA cases is their size. And the basic problem when the cases get too big is that we, the victim advocates, lack leverage. And Howie Erickson has just written a great article on this, The Problem of Settlement Class Actions, in which he really crystallizes the point, which is if the claims are not triable, there's no stick to induce the defendants to make payments that bear much of a relationship to the victim injuries. All you can hold out is the carrot of res judicata effect of the settlement, but there's no real threat of trial. And that certainly explains part, I think, of what happened in the Holocaust cases to the extent we settled non-triable claims, and explains, in part, why the ATA cases resulted in such a dramatically different outcome. They were actually tried to a verdict in federal court, with a jury rendering a verdict just for 40 plaintiffs, for $218.5 million, trebled to $655.5 million. I don't have time to go into a really detailed explanation of all the differences between the ATA cases and the Holocaust-era cases, but I do think a core difference is the way the cases were aggregated, the definition of the boundaries of the dispute. I think the ATA litigation presents potentially something that plaintiffs' counsel in mass human rights cases don't necessarily think of as an attractive option, but the possibility that less is more, that a smaller group, a triable unit of adjudication might produce better outcomes. Thank you very much.
Thank you. Mr. Tzachi Fistel is a partner and head of class action department in Ben-Ari, Fish, Saban & Co. Tzachi mostly represents defenders, but in some cases with social impacts also represent plaintiffs. Tzachi.
Thank you, Menachem. I'd like to also thank Rabbi and Ariel and Lily for this wonderful conference, and hope it will become an annual international conference, one of many. Professor Patrick Nero, a French-Italian philosopher of law, claimed that meaning comes from the end. The real meaning of events, certainly meaningful events, is always learned in retrospect. I'd like to share with you that this year I lost a close and dear person who was a moral teacher, leader, and mentor, Advocate Adam Fish. He passed away about a year ago, suddenly and by surprise, while riding his bicycles. He was only 57 years old. Over the last year, I discovered that Adam, during his short life, had an impact on not only on me, but on hundreds and thousands of people who truly felt the harsh sense of loss that I felt upon his passing. Over the last several years, Adam and I established the class action litigation department in our firm. The department, as Menachem said, is for the most part based on representing defendants, but out of awareness to the power in our hands, we chose from time to time to represent class action plaintiffs, filing class action against the state, mainly the state and its authorities. Over the course of the last year, and especially in the last several days, almost a year after Adam's passing, I could not help but wondering what is the meaning of Adam's passing for me. Recently, it became quite clear to me that is a moral imperative to continue down his path while remaining truly committed to telling his story and sharing his legacy, a legacy of helping vulnerable population. Adam was a very convincing person, always able to look at things in a positive way. You couldn't help but being impressed by his ability to say to a client in difficult situations, this is the best thing that could have happened to you. And continue with an argument in which he would convince him that was really correct. Thus, for example, I'm more than convinced that this is exactly the sentence he would tell me if he knew how hard I took the news of his passing. Tzachi, he would say, you don't understand it now, but this is the best thing that could have happened to you. Today, almost a year later, I understand that in a certain way, apparently Adam needed to pass away in order that I and those like me who surrounded him will be able to tell his story and inspire others in the hope that they would also follow his path. In Hebrew we say, "En anachtó me'id al isato." Don't blow your own horn. Even though Adam was a great storyteller, and he was, the story of Adam and his work will in fact be best told by others. As I mentioned before, Adam's true legacy was the assistance he gave to vulnerable population. Adam helped vulnerable population in dozens of cases, battling powerful entities, starting with the state and its authorities, when the latter chose to turn a blind eye to the pain suffered by members of those populations. In this sense, the Israeli legislator provided vulnerable population with a wonderful and powerful tool, the class action claim, a unique tool which permits access to courts without any court fee or legal fee, a tool of the highest order for real social change. Thus, for example, in Israel, as in the US, it is possible to submit a class action claim free of charge, even against the state, based on the claim of discrimination. In this context, almost every jurist knows the Brown versus Board of Education case by heart. Very few of us are aware of the fact that this lawsuit was conducted as a class action claim. In this context of battling for social changes, Adam taught me a very important lesson I'd like to share with you. A lesson which is not taught in law schools, not even in law firms. He taught me the importance of loss, the importance of conducting litigation in favor of a vulnerable population, even if on its face it is clear that you will likely lose the case. I will illustrate this point using a real case which I handled with Adam, the case of Naamat Zoref versus the National Insurance Institute, the NII. But first I will explain the outline of filing a class action against the state and its authorities, and afterwards we'll go back to this specific case. The Israeli class action law permits the filing of a motion to certify a class action against the state of Israel for a line of specific causes. I won't mention each and every one of them. Reshef will elaborate on it, but I will mention a few of them. One example is when the state acts as a commercial business. Another one is when the state violates antitrust, anti-discrimination law. Another example is when the state violates the environmental protection law. Thus, for example, the Israeli Erin Brokovich was easily able to file her lawsuit as a class action claim in Israel. And I know that that's Julia Roberts, but okay. It is important to know that unlike my former examples, if a plaintiff wishes to file a motion for a class action against the state for an act performed by it as a sovereign body, as the state itself, said motions could only be filed for restitution of amounts which were unlawfully collected as a mandatory payment. Additionally, in this case, the state granted itself two primary defenses mechanisms. The first, cessation, meaning the cessation of the prohibited collection. In such case, the proceeding ends without the money being returned to the class. The second, a short statute of limitation. In a case where the state decided not to give a notice of cessation, then the statute of limitation is of 2 years and not the usual 7 years. Let us go back to the specific case I mentioned before. This is Naamat Zoref versus the NII. Naamat Zoref is an orphan who lost both of her parents to an act of terror committed by a suicide bomber. The NII, which is an institute in charge of paying families of victims of terror, did not pay millions of shekels to bereaved families, amongst them Naama and her brothers, for the benefits to which they were entitled. Naama came to our office wondering whether it was possible to file a class action lawsuit against the NII. As I mentioned before, a class action motion against the state can only be filed in respect of unlawful collection and not in respect of non-payment. Under these circumstances, I explained to Adam that this kind of motion will not be accepted. And if we do submit it, we would probably lose and likely to incur even significant expenses. As I indicated earlier, choosing to lose in order to advance social interest was a very important value in Adam's eyes. And he immediately instructed me to submit the motion, despite the very real likelihood that we would lose. What happened afterwards was nothing short than amazing. In the months after the submission of the class action motion, the NII provided the bereaved families with all of the millions of shekels which had not yet been provided to them, and this for the past 7 years, not 2 years. Furthermore, the NII's arguments of the lawsuit not being fit to be litigated as a class action lawsuit were rejected by the court, who also ordered handsome sum as attorney fees. When the court, actually I said the court, I mean discreet Judge Michal Nadav, who sits here in our audience today. So when the court recognized that we were defending a real social interest, it accepted the certain flexibility for interpreting the law as we proposed. I wish I could describe such a utopic picture in the world of class action litigation in general, but the general picture of the Israeli class action litigation is quite different. Many class actions, including those who seek to defend vulnerable population, are denied, sometimes on the basis of various technical grounds. Having said that, I must note, for the sake of fairness, that Israeli class action plaintiffs are very creative, to say the least, and so are also to blame for the fact that Israeli courts recently decided to temper a bit the enthusiasm for class actions. I will list a number of examples of the Israeli creativeness when it comes to those kind of motion, kind of ridiculous motions that were truly filed to the Israeli courts. The first one is Avrahami versus Haifa Municipal Theater. This motion is a motion to certify a class action lawsuit in respect of enforcement of the law prohibiting smoking in public places. In Israel, there is a law prohibiting smoking in public places. According to the law, when a person smokes in a public place without being told to stop, the injured person has the right to file a class action lawsuit against the public place, which didn't enforce the law. In our case, the smoking was in public place, in a closed hall, during the course of a play in Haifa theater. And indeed, the smoker was not told to stop. Only one small fact. A bit changed the picture. The relevant smoker was an actor on the stage and was smoking as part of his role in the play. Obviously, this motion, as well as, you won't believe, as well as the appeal were denied. There was actually appeal in this case to the Supreme Court. I know the facts, but it was denied, yes. He didn't get any money for it. Yes, and the appeal was denied. Avraham Lalo, the second one is Avraham Lalo versus Bank Hapoalim and Yediot Achronot. Just before the Israeli Independence Day, readers of the most widely distributed newspaper in Israel received the Israeli flag as a gift. It's kind of tradition in Israel. The plaintiff, an American Jew from Florida, who was visiting in Israel, bought the newspaper in order to get the flag with it. However, he was gravely disappointed when he discovered that the national flag which he received was non-standard, whereas the violation of the national flag symbol and anthem law, the bases of the triangle on the national flag were not parallel to the blue stripes along the flag. This, by the way, was because the flag was intended to be hung diagonally. Of course, this claim was also rejected. Another two funny examples, once again, of the creativeness of the Israeli plaintiffs. Tali Lupo against Orgad Holdings, a class action lawsuit against an Israeli fast food company. The plaintiff ordered a regular ranch and claimed that the taste of the hamburger differed from the normal taste. Accordingly, she claimed that the chain misled its customers when it served hamburgers which taste different than the known taste of the chain's traditional hamburger. This lawsuit as well, which related entirely to the plaintiff's taste buds, was rejected. The last one is Ziad Qassem versus the Central Drink Manufacturing Company. The plaintiff claimed that the respondent, the manufacturing of Coca-Cola in Israel, discriminated against the country's Arab citizens when the framework of the campaign, it typed first name of people on its products, on the bottles, you see it, and did not include any names identified with the Arab population of Israel. This claim, I call it rejected, but it was rejected afterwards. It should be noted that these kind of class action claims severely harmed the image of the Israeli class action plaintiff in the eyes of the court, as you could notice from the things said yesterday by Chief Justice Grunis. They also harm the image of the class action plaintiff in the public. And more than that, it causes a significant damage to the institute of the class action lawsuit and its purpose. On the other hand, more than a few appropriate class action claims were filed in Israel, which attempted to, and some even succeeded in advancing appropriate social change and defending vulnerable population. I will note a number of examples of these lawsuits as well. The first one is Kowalski versus Ortal Manpower Service, a motion to certify a class action claim submitted to the labor court by a pregnant woman against the employee placement company, which refrained from offering her and the other pregnant women jobs during the period of their pregnancy. In the settlement agreement, the respondent undertook to compensate the women harmed by the company and, of course, to change his unlawful conduct. Another good and typical Israeli example, because of the religion-state conflict we have, is a motion named Izor Ruth versus Eged, a motion to certify as a class action lawsuit claiming discrimination of women, Orthodox women. The motion was submitted against a bus company for a line between Jerusalem and Haifa, a Mehadrin, a kosher line, in which there was a separation between men and women. You guess where the men sits and where the women. The motion was granted, but a motion to leave to appeal is currently pending in the Supreme Court. A final and interesting example, which I would like to share with you, is an example of a representative loss which must be seen as a collective win. In 2007, a petition was filed dealing with discrimination against Israeli Arab in the framework of secure inspections at airports in Israel. The ruling on the petition was delayed on the petition, yes, not the class action, the petition, was delayed over many years because of the state's claims of changes which would be applied by it in the future. In fact, over 7 years, the security system was not implemented, and it was only claimed by the state again and again that it would be implemented shortly. Yes, 7 years. In 2011, a motion to certify class action lawsuit was submitted in the same matter, in the very same matter. One of the plaintiffs, Advocate Yaman Masalha, sits today here in the audience. Though the district and the Supreme Court denied the class action motion, as well as the appeal of the decision to deny it, it is obvious to me that the pressure placed on the state by the class action litigation caused that during the following year, the new security inspection system was implemented in full. Advocate Masalha has informed me that the new system dramatically improved the treatment which Israeli Arabs receive in the framework of this inspection. This is a wonderful story of losing the battle but winning the war. The specific representative plaintiff did not win a financial reward, but they did succeed in benefiting an entire population. I'm more than sure that Adam would have really loved this role of event, maybe except the fact that no attorney fees was relevant there. In conclusion, let me remind you the words of Professor Nero. Meaning comes from the end. The Israeli legal system in the field of class action litigation is still taking its first steps. Therefore, it is still too early to fully understand whether this important tool will know how to create appropriate meaning or not. One appropriate meaning, in my eyes, is creating an inclusive system which opens a large portal for defending the rights of vulnerable population. One obvious way to do so, in my eyes, is by creating true incentives for attorneys choosing to promote this kind of goals. Thank you.
Mr. Reshef Chen is the legal counsel for Haifa City Municipality, a former member of the Knesset. As member of the Knesset, he presented the private bill and chaired the subcommittee of Law and Constitution regarding the Israeli Class Action Act.
Thank you. Firstly, a personal note. There's no way I can deliver this lecture objectively. I'm not objective on this matter. When I became a member of Knesset, I was concerned with the lack of redress on issues of civil rights. And with this in mind, I tried to promote two bills in two avenues. One eventually became this, the Class Actions Act. The other was a constitutional tort correction, a small correction to our tort act, which will enable plaintiffs to bring an action claiming that a constitutional breach is a tort in itself. Some of you may have noticed that Daphne Barak-Erez wrote a book called The Constitutional Tort. She tried to promote the same idea. This never lifted. This never went anywhere in Israeli law, and I thought this would be a good idea. I tried to promote it and failed miserably because the government opposed it totally. And some of you may know that in Israel, if the government opposes a private bill, it usually doesn't go anywhere. By the way, this act, this bill is the exception to the rule. Now, the issue of the ability to bring a class action against government, and by government I mean all forms of government, the state and local authorities as well, has always been probably the most moot question, the one thing that was the problem and the point of argument in relation to class actions in Israel. To begin with, Rule 29, which is quite similar to the British rule, I think it's actually identical, which could have enabled class actions in England as well, was general. It applied to government as well as to anybody else, but it was rendered useless by the court ruling that, in fact, made it only possible to bring actions on non-monetary issues, because the ruling said that if there is a difference in the monetary sum of compensation, that in itself prevented a class action. Then, by the way, I think because of an influence of an American professor, the late Professor Goldstein, there started a slow process of bringing into the Israeli legal system of class actions. And this was done by specific changes to specific laws, which enabled bringing class actions under these laws and under the causes of these laws only. And then we had banking, insurance, consumer, securities, environment. Other than environment, also work relations. And it was done piecemeal during the 80s. And you'll find that in most of these areas, the government as government is not a player. And I actually know that this was done on purpose. Now, then we had this major case called Eshet. And it's no coincidence that this case was brought against government. It was brought against the government under Section 29 because it didn't fall into any of these categories, and it was possible to bring it. It was a monetary claim for reinstatement of unlawfully collected taxes. And the government went in and said, you can't use Section 29, and it's not in any of these specific laws. It wasn't the first time government put in this opinion. There was at the time a divergence of opinions in the Israeli court, and the county court ruled that actually against the government. It went to the Supreme Court. Supreme Court said something quite interesting. It said it's possible to use Rule 29, but because of judicial preference, they wouldn't do so. They prefer Parliament the Knesset actually, to legislate a more elaborate system for class actions. And the issue of the applicability of class actions to the government was one of the two issues that were actually dealt with in Eshet. One was Rule 29, yes or no, and the answer was possibly but not yet, or not now. Let's see if the legislator does something about it. As for government, there was the same divergence of opinion. There was a majority and minority in Eshet. But the same majority that thought that Section 29 shouldn't be applied also said that maybe government should be given a special treatment. And the main argument for that was that, especially in Israel, the judicial review process is extremely strong, stronger than in other common law jurisdictions, because we simply did away with the concept of locus standi. Anybody can go to the Supreme Court in Israel and say, this is wrong, government is doing something wrong, I want it fixed. And it doesn't have to have any claim in himself. It can be a public petitioner. So the argument was maybe class actions aren't that necessary in Israel, and the later President Beinish put forward this argument. When this judgment was published, after I think about maybe 3 days, I put forward a private bill, and basically it was very short, and it was a total plagiat from the specific laws that were at the time, and it basically said, okay, you can bring class action against anybody for anything. And it was a little more elaborate than Rule 29. It was passed, I won't go into the political working of the Knesset. It was passed because I was in the coalition, and we usually pass laws. We pass laws for coalition members to get a good commentary in the papers. But I agreed to wait for the government, because government promised the Supreme Court that it was going to put forward a government bill. Most bills in Israel and in other places are put forward by the government. And then about 2 or 2.5 years passed, and government did nothing about it, because I don't think it ever planned to fulfill this promise. It wouldn't be the first time that government promises something to the Supreme Court and waits several decades. But then there were changes in the Knesset. Again, so I won't go into many details. I was then in the opposition. The coalition was breaking apart. And in the Law and Constitution Committee, we decided that we can go forward. We don't need to wait anymore. I promised to wait, but I didn't promise to wait indefinitely. So Miki Eitan, who was the chairman of the committee, gave me the authority to preside over the subcommittee, which would enact the Class Actions Act. The first thing I did was to throw my bill in the bin and take out the government draft, which was already circulating, and decide to work on that. So if you ever look at my private bill, compare it to the final act, they have absolutely nothing in common apart from one clause, which was, it was very important for me to specifically make sure that the attorney owes a fiduciary obligation to the class. There was a question whether he works for the plaintiff, the individual representing plaintiff, or for the class. It was very important for me to make sure that from the first day, from the beginning, he owes his obligations, his fiduciary obligation to the entire class. That's my only real personal contribution to this issue. Anyway, we worked on the bill, and then there was this major argument, because now we have to stop and think about the government. The government is in a conflict of interest here. The government is the regulator. First of all, that's the body whose failure we are trying to correct through class actions. Because if the regulator was operating perfectly, there would be no need for class actions. So that's one problem, not the major problem. The government, by definition, is a classic defendant in class actions. Government works vis-a-vis a tremendous amount of customers. It does millions of transactions. It makes a lot of mistakes, not intentionally necessarily, and it can really easily find itself in a position of being a defendant in a class action. So you had these two factions within the Justice Department. There was the litigators, the general attorney it would be, who were dead against this entire process. They wanted to kill class actions at all costs. And then there was the General Litigation Department, who thought it was a very good idea for regulating the markets, because the regulation was failing. So there were these competing views, and basically the compromise that they reached within themselves was, okay, let's have class actions, but not against the state. I thought, well, this was a terrible idea. I thought this was immoral. I thought this was wrong. I thought, personally, this is why I started with the constitutional tort thing. My private purpose was specifically government. I was less concerned with the commercial markets than with the government. I wanted to use class actions in order to regulate government. So this became a major point of conflict. At the beginning, I was relatively strong. The bill went for the first reading as applying to everybody. There was no specific, there were hardly any specific clauses relating to the government. And the focus of the argument related to the list of clauses. Because what government wanted to do was to to broaden the same system that they used before with a specific clause. But instead of having, say, 5 or 6 different acts, would have a single act with a list of possible clauses. And guess what? These clauses wouldn't include the one major clause that does apply to government, which is return money that you took unlawfully. And so I opposed the idea of having this list. I said, if it's a good case for a class action, that's good enough. If the class is big enough, the issues are similar enough, we should be able to sue the government just the same as anybody else, which is the way that the entire world goes. I don't know of any other country that has a list of clauses. So it went to the first hearing without a list of clauses, and it went all the way almost to the end of the enactment of the act without a list of clauses. But then, and there was a major conflict. There were arguments. It was pretty fierce. But then a political change happened. The Knesset decided to disband. And I already announced that I wasn't returning to the next Knesset. And government felt that, okay, that's it, the problem solved. And then we started to have this quite funny political ping pong. I convened the Knesset committee. The Knesset committee, I have to tell you, there's a rule in the Knesset which says that there is no, once the Knesset goes into recess, election recess, no private bill can be brought to the final hearings unless government agrees. So they were in power. But there's another rule in the Knesset which says that the Knesset committee can overrule any other rule. So I convened the Knesset committee, and the Knesset committee unanimously agreed that this bill will go to the final hearing. So I thought, okay, I won. But, however, government went to Ruvi Rivlin, who was then the chairman of the Knesset. And they said, this cannot happen. This is terrible. How do you let the Knesset change all the rules? And he called me and said, I'm not going to allow this. And I said, this is illegal. The Knesset committee decided I will go to the Supreme Court. I will win. He said, yes, you will win, but it'll be too late. By that time, by then, the Knesset will have already dissolved. So I said, okay. You know, I went from being very forceful to begging. I said, okay, what should I do? We were in good relations. He said, you should speak to Tzipi. That's Tzipi Livni, who was then the Minister of Justice. I called Tzipi Livni and I told her, look, this is a good law. I'm trying to do something good for the public. Why are you stopping me? So she said, well, my people are saying that you're demanding too much. Speak to them and find a compromise. And then I met with Sarit Dana, who was then in the Justice Department, the deputy legal counsel, and we sat in the coffee shop in the Knesset, and on a piece of paper we wrote down a list of special clauses for the government. Now, and this is how we reached a compromise. And what you see in the law now, in the act now, is this compromise. And you will hardly find any parts of it in the subcommittee's protocols, because it all happened after the subcommittee had already finished its entire deliberation. Some of them are a bit previous to that. Now, what was the compromise? First of all, my huge defeat was that we have a list. I agreed to have the list which the government wanted. Now, it's a broader list than, it's much broader than what was before the law was enacted. Like Tzachi said before, many parts of it do apply to the government. Work relations, environment, and other aspects do apply to government in many respects. The one thing that was missing was the clause that will force government to return money which it took unlawfully. And this was their compromise. We added this clause. It's called Section 11. And this is the main clause that's used against government. And I'm pointing to myself because, ironically, now I'm on the other side. Now I have to deal with many of these cases, including the one about the cigarette in our theater. So we had this compromise, but this wasn't enough. We added a list of special defenses to the government, and I will mention them. First of all, in Section 3A, there is a specific defense against a claim based on exercising of a regulatory power or a failure to do so. This was extremely important to the ministry, the Treasury Ministry, because they felt that this will open the door to claims against government bodies for failing to make sure that somebody else doesn't act properly, doesn't act legally. And I thought, and this was before this compromise, I thought this was a valid argument. I don't think class actions, I think class actions should be directed towards the person or body who acted wrongfully, and not against the deep pocket of the government for failing in its regulatory power. So this wasn't a problem. Another one, Section 5B2, is a forum convenience on monetary issues relating to the government. The argument was that the regular courts are not familiar with the special law that developed regarding government, and that we should go to the courts that are used to dealing with government, and that would be the county court in its position or its role as a judicial review process. So we have a special section in that respect. Then we have two, in Section 8B and Section 20D, two discretionary powers to the judge, allowing the judge to not to sanction a class action. That's 8B, and yeah, I'll find out. Yeah. And in 20D, not to award full compensation in case he feels that this would be harmful to the public. Again, this is something that was brought in from public law, general law. And then we have the really special one is Section 9. Section 9 says that in claims under Section 11 of the second appendix, which is return of unlawfully collected taxes, there is a mandatory delay of 90 days. Within that time, the state, the government, has the opportunity to cease and desist. And if we cease and desist, then the class action cannot be put forward. The idea is that the purpose of the class action against government, especially against government, is not redress to the class, but the correction of the behavior of government. And once this objective has been reached, because government said, okay, we're correcting our ways, it has to actually correct its ways. It has to actually stop collecting the tax which it had been collecting illegally. It doesn't have to return it, but the class action stops. This doesn't create a binding legal finding against the general public. Individuals can still bring the lawsuit themselves, but the class action stops. There's an interesting addition to that. Lately, the Supreme Court ruled that it's mandatory for claimants, for plaintiffs, to approach government bodies beforehand, before they go into court, and tell them, you're doing this and that wrong, stop. And if the public authority actually stops, then the claim can't be brought into court. So all of you plaintiffs will say, okay, why should I do it? What's in it for me? Which is, and I totally agree with the previous comment, that there's absolutely nothing wrong with lawyers and plaintiffs, mainly lawyers, wanting to earn a fee through class actions. This is the mechanism of the entire process. So the Supreme Court enacted a whole new procedure, doesn't exist in the law at all, and basically we're supposed to agree with the plaintiffs, the authority is supposed to agree with the plaintiff on a fee, and if they disagree, they can go to court. This is quite problematic because under the law, the entire process of this agreement is seen as something very dangerous. But the Supreme Court felt it was okay. I think especially because, again, it doesn't create any legally binding ruling towards anybody, not even in the terms of the class action. So it's less dangerous. Okay, my time's up.
Okay, thank you very much. We don't have any more time. Okay.